Welcome to Legal 123s with ByrdAdatto. Legal issues simplified through real client stories and real-world experiences. Creating simplicity in 3, 2, 1.
Welcome back to another episode of Legal 123s with ByrdAdatto. I'm your host, ByrdAdatto, with my co-host, Michael Byrd.
As a business and healthcare law firm, we meet a lot of interesting people and learn their amazing stories. Our clients commonly come to us, Brad, with the latest word on the street that they heard from a friend. This season, we will talk about stories with a common legal or urban legend to them and seek to either prove or disprove the legend. This season's theme is fake or real.
All right. Well, Michael, as we've discussed in past shows, I'm really the historian of the show.
Brad, I can't believe you're starting us off like that. Yes, I will acknowledge that you took history in college and that you have a lot of useless information, but we're not going to give you something as scholarly sounding as historian.
Okay, fair. Would you say that I keep up with current events more than you?
Yes, but that's really not bringing you up to historian status. It's just saying like barely above the 13-year-old surface.
Okay.
But what does this have to do with your claim of being a historian?
Well, as someone who studied history, during the Cold War, NATO countries were constantly looking out for Russian spies, and obviously trying to catch a Russian spy was a pretty big deal for the CIA, FBI, and other NATO partners.
And for those of you who are not as old as Brad and I, the Cold War is something that happened a long time ago. And since Brad's a historian, he can educate you on it. But it was the standoff between the United States and Russia. And if you were a child during this time, you were terrified that a bomb was going to go off in your city at any point, a nuclear bomb.
Right. Well, and obviously it's this a little bit of escalation going on with on the edge of Europe, a little war going on, which I won't dive too much on. But all of a sudden, there's a lot of more articles appearing from other. What are the Ruskies up to, and do they have spies in their country?
Okay, well, keep going, Brad.
All right. Well, the country of Sweden might have identified the largest spy ever recorded, which, of course, the Russians are denying.
I speak Brad, so I think you might have skipped some words and should have said the largest Russian spying operation ever recorded.
Actually, generally, you would be correct. But this spy, his approximate weight is close to 3,000 pounds. And it appears this spy might be even trying to escape his Russian handlers when they noticed him.
Okay, I'm biting my tongue, Brad, but just give me some context and tell me where you're headed here.
Oh, did I fail to mention that this alleged spy is a tame beluga whale?
Yes, you did fail to mention that, Brad, although the 3,000 pounds eliminated most everything else in the world. Is there anything else you'd like to add?
Yes, the whale was first spotted off Norway's coast in 2019 wearing a Russian harness.
Ooh, fancy.
Having spent years traveling slowly southwards from Norway far north, and the whale has sped up his movements outside of Norwegian waters in the recent months. The whale has first been seen approaching Norway about 250 miles from where a Russian Northern Fleet was based. The whale was wearing a harness fitted with a GoPro camera mounted and the clips bearing the inscription, "Equipment of St. Petersburg."
Well, that's not very natural sounding. He's not really, other than just his invisibility of being in the water and being a whale, all that equipment and the harness, I'm picturing like a Russian uniform, kind of gives him away.
Yes, well, then, and the Norway's domestic intelligence agency believes that this whale is likely to have been trained by the Russian army or military, and Russia, for its part, has never officially addressed the claim that the whale is trained by the Russian military. Apparently, it has previously denied the existence of any program seeking to train sea mammals as spies.
Well, this could be, a pretty amazing episode of Punk'd if, they're dressing up a whale to look like a spy.
Yes.
So where are you going, Brad?
Well, let's get started and see if this whale of a tale has any bearing for today's story.
Boy, you just jumped off a cliff with that dad joke there. Okay, Brad, you're starting to lose me here, but let's hear today's story and let's try to minimize the dad jokes.
Okay. I'll try. The main character in today's story are entrepreneurs named Boris and an RN named Natasha, who would like to start their own IV center, therapy center. And they've been speaking with Dr. Rocky on having him act as the medical director for the IV bar.
Okay, Brad, I think you're dating yourself if you think anyone is going to know that these characters' names are from the cartoon Rocky and Bullwinkle, which, by the way, was from the 1960s. And they had this show had a flying squirrel, Rocky, Bullwinkle, a moose, and they were chasing after two Russian spies, Boris and Natasha.
Actually, Michael, I believe they made a remake of this movie actually more recently.
Okay, well, according to Siri, Brad, you are correct. They did make a remake 23 years ago.
Oh.
So I'm really proud of you for being modern and really trying to squeeze the opening banter into this story right here.
I think there was a thanks in there somewhere. So Boris and Natasha were staying in Vegas and both needed some help after partying a little too hard one night. They were staying at a high-end hotel, which offered IV therapy to its guests to help recover from a hard night of drinking lots of fluids.
Yeah, I mean, we are in Vegas a lot on our speaking at different medical conventions, and you can't get on an elevator without seeing an advertisement for the IV hangover cure. So that makes sense.
Yes. So when they returned to their home state, they decided to copy this exact format as they had seen in the hotel. Well, at least what they thought was the exact format. That's what they saw in the hotel.
Sounds like we have some foreshadowing happening here. Do we need to get Riley to cue up some horror music, Brad?
Maybe. Well, Boris put in the startup capital to launch this new venture, and Natasha was a trained RN, started seeing patients providing IV for a host of treatments at the Beluga IV therapy bar.
Okay, seeing what you're doing there with the old Beluga IV therapy bar, Brad.
Well, these treatments were for, hangover helpers or helping a patient recover from a flu or a cold or weekly, because you were working out too hard. These IVs, they had a host of additional supplements that, depending on the need of the patient, the RN would work with.
Okay, Brad, it appears you're skipping around a little bit today, but I'm trying to follow the bouncing ball. When Natasha was rendering all this care, what was Dr. Rocky's job?
Oh, well, Dr. Rocky developed standing orders that Natasha had to follow so that when a patient arrived at the IV bar, Natasha would ask, have this questionnaire that the patient would fill out, and she'd ask the patient, and depending on the outcome, the answers, Natasha would then follow these standing orders with the proper IV ingredients.
Well, I'm sure our loyal and longtime listeners are still wondering when and who was conducting the good faith exam. And so for those who haven't heard this, the good faith exam is a part of the treatment process that applies in every state in the country. It's not always called officially the good faith exam. Sometimes it's the initial exam, but the essence of it is the requirement that if a medical treatment is being provided, that someone with the right scope of practice will see the patient's history and physically examine and determine that a treatment is appropriate.
Okay, Michael, apparently you didn't hear the earlier part of the story. I said Natasha had standing orders from Dr. Rocky. So, they decided they did not need a good faith exam at all. They didn't have to have any PAs or NPs working at that facility.
I want to jump in and respond to that, but my context brain is going off. First, tell me where this IV bar is located. What state are they in?
Oh, Alabama.
Oh, okay. And when did they start this business, Brad?
Approximately July of 2021.
Okay, this story is now starting to make a little sense, Brad. IV therapy in many states has been like the Wild West from a compliance perspective. People from different backgrounds have jumped into the IV therapy services industry. So before I follow up on the standing order statement you made earlier, are there any other aspects of the story you want to add?
Sure. I guess I'll give some more context to you. So the first year went well for the Beluga IV therapy bar as it grew with clients and staff. And In fact, by July of 2022, they had grown so quickly they were hiring new RN. This one was named Bullwinkle for some reason. However, things came to a grinding end when they received a cease and desist letter from the Alabama State Medical Board of Examiners, noting that they were non-compliant with the state law and can no longer continue providing IV services.
Well, I guess we can. I don't need to directly respond to the standing orders thing based on that outcome, but I have a feeling we're going to talk about that on the other side. Brad, why don't we, with that news, go to break and learn what happened on the other side and talk about the elephant in the room, or I guess, should I say the whale in the room? Ooh, fake or real? I can use standing orders for my IV bar.
Many business owners use legal counsel as a last resort rather than as a proactive tool that can further their success. Why? For most, it's the fear of unknown legal costs. ByrdAdatto's Access Plus program makes it possible for you to get the ongoing legal assistance you need for one predictable monthly fee. That gives you unlimited phone and email access to the legal team, so you can receive feedback on legal concerns as they arise. Access Plus, a smarter, simpler way to access legal services. Find out more. Visit ByrdAdatto.com today.
Welcome back to Legal 123s with ByrdAdatto. I'm your host, ByrdAdatto. I'm still here with my co-host, Michael Byrd. Now, Michael, this season theme is fake or real. And, we have, as you said, a whale of a big question, I think, something of that sort that everyone really, really wants answered, Michael. And maybe kind of recap a little bit of the story.
Yeah, I can't give you a hard time for the dad joke because I threw one in as well at the end.
Did,
so, the story is a common one that we're hearing more and more over the last several years, and that is, the Wild West of the IV bar scenario. And in our story today, we have, two characters who were in Vegas and saw the kind of the benefits of the hangover cure for the IV,
and everyone's doing it,
and so they went to go. They received the services when they were there, and then they went to their home state of Alabama to do it. And it's that it's super common. I mean, whether we see it, the call from the EMTs who put IVs in every day, or the nurses at the hospitals, nurses that are in some other specialty, they see the opportunity for elective medicine, and it intuitively makes sense because most of these IVs are, as you mentioned earlier, vitamins or something to that effect that will have some sort of moderate health benefit. And so it all feels like my word, quasi-medical type treatment. It's kind of something they do all the time in the normal course of their business. And so, they go open a business that's very retail feeling. And that's what happened here. And one of the things that you kind of alluded to during the story was that there were standing orders in place. And essentially what that means is that the doctor has basically said, here's how you're to do the IVs, and the doctor signed off on it. And so, the process, and I'll say this to you to correct me if I'm wrong, in the story was that, someone came in off the street to get their IV, and they would see the nurse, and the nurse would probably take their patient history, but utilize and rely upon the standing orders to then go ahead and issue the treatment once the nurse said they were good to go. Is that accurate?
Yeah, and that's fair. And that's they called it a questionnaire, which is why I was using that term. But that was like, here's a questionnaire, and depending on how the patient filled it out, that standing order then would reflect what to do.
Okay. So let's kind of unpack this a little bit, Brad, and I'll have you start, if you don't mind, give kind of a legal recap starting at the baseline. When what is the practice of medicine and why that is relevant here?
Yeah, and it's very relevant to this situation. And every state's going to define the practice of medicine a little bit differently, but generally speaking, when there is a diagnosis or some type of medical treatment plan that needs to be put in place, that you start falling into the practice of medicine. In some states, you go further in, meaning the moment you start actually affecting living tissue.
Mhm.
That could be either the piercing of the skin or the freezing of the skin or the burning of the skin.
Mhm.
Again, lasers and
What about sticking a needle in your arm?
so sticking that needle in the arm, yes, is generally the practice of medicine because you're piercing the skin. So good catch there, Michael. You're paying attention. Very
Mhm.
proud of you. I thought you were asleep there for a second. And what happened in this particular case is, so that's a general rule, and since this particular group is based out of Alabama, the state of Alabama, they actually went further in. So the State Board of Medical Examiners there, they noted that the diagnosis of a patient's condition and a recommendation of IV therapy actually constitutes the practice of medicine. Now, the important element there, Michael, is it's not I think this could be because you pierced the skin. The board said, no, this is because there's some condition here, and because you recommend IV therapy, that is the practice of medicine. Additionally, because of that, that means that something has to occur. And I think you kind of hinted to this earlier when you were projecting to something I said, and you might have even mentioned the GFE, the word in the street called the GFE, kind of like your biceps has GFE for some reason, which is the good faith exam. And Michael, you kind of gave a general rule about what is the GFE, but the state of Alabama medical board actually went further into it and noted for an IV treatment who could conduct that GFE.
Yeah, and before I talk about the GFE, something that jumped out at me that the Alabama did that we believe every other state would do is they made it super clear that IV is the practice of medicine.
Yeah.
And we've been screaming that from the rooftops ever since the IV therapy business started exploding, and Alabama was the first state to confirm what we thought because of this broad definition that you were talking about that most states have. They made it super clear. And then they also went further, as you noted, to clarify what is the good faith exam and what does that mean, and that in Alabama only a licensed physician or a physician assistant, a certified registered nurse practitioner, or a certified nurse midwife legally practicing with a physician may diagnose a patient, assess their symptoms, and recommend an IV for the treatment of the patient's condition. And so, Brad, we get a lot of pushback from RNs when we mention this. And as I said, this is probably the rule in every state. We just have that clarity in Alabama. But talk a little bit about why do we receive that pushback from RNs?
Yeah, and this is a scope of practice issue that, and for audience members who've heard us talk about it, every single professional up and down the food chain in the medical industry, between your physician assistant, your nurse practitioner, your RNs, your LVNs, they all have a scope of practice which is defined either by state law, or it's defined by and normally fleshed out further by the medical board or the nursing board, or sometimes the cosmetology board, depending on what they're allowed you to do. So the concept is that scope is what you're allowed to do. And a lot of times when you go into reading in many states, an RN scope of practice, there's three elements. There's many elements they can do, but they can help take and you were talking about the good faith exam. So the good faith exam, audience members, take a step back. There's three basically elements. Is the medical, in the very beginning is conducting a physical examination, which if you look at the scope of practice, an RN can do that. The next step is obviously reviewing the medical history, which again, if you look at the scope of practice, an RN can actually do that. The third element of a good faith exam, though, which they cannot do, is come up with the actual treatment plan. So that's actually where an RN's scope of practice ends. They can do the first two steps. And in several states, it notes that an RN can start an IV line. So they would assume, oh gosh, well, if I can do the medical examination and I can do the review of the history, and I can put the IV in, therefore I should be able to then determine what to put in there. And that's the case where a lot of RNs start pushing back. But the follow-up question obviously is, well, what are you putting in there? Sticking the line in is just a piece of it. Putting the liquid therefore would mean you're going further through it. So, which means an RN could administer the IV therapy. However, again, in the state of Alabama, they said yes, they could, but it has to be after the good faith exam had been conducted based on that. Again, you described in Alabama, the appropriate medical provider who had to look at that. And today's, story, it really centers around that standing order. So we've established that, they have the scope to actually do the actual IV and put it in. So I think at this point in the episode, Michael, we're going to have to answer the promise here. We promise that we're going to answer fake or real. Can I use standing orders for my IV bar?
The answer's fake for what everyone thinks it is, Brad, because it's fake because people think standing orders can replace the good faith exam.
Mm-hmm.
And that's the danger. That's why in the story today, they and many of their friends got shut down by the state of Alabama, and why there's risk in every other state. And so I will pause to say, does a standing order have relevance? Yes, it does, actually. So if you think, and this actually applies, kind of across the country, if you think about how do you delegate and supervise and delegate medical treatments, you have, as part of this treatment process, you have the good faith exam conducted by someone that has the scope of practice to exercise independent judgment.
Mm-hmm.
And so they do a treatment plan, and they've got it, and they've determined that the IV is appropriate. And at that point in time, they can delegate that treatment down to someone in that state that has the scope of practice. In virtually every state, if not every state, RNs can be delegated, putting an IV in an IV bar type scenario. As a part of that delegation, what every state requires is a set of written protocols or SOPs. And guess what, Brad? Standing orders are just a different name of the same thing. It is in writing. This is how we do the treatment. So the standing orders, in a sense, can work if that's the function, as the written protocols that are signed off on by the supervisor, the supervising physician, to say, this is how we're going to do these treatments. And that ends up being actually very protective to everyone involved. It's protective to the delegating physician because it's super clear, this is how we do things. And of course, presumably that's within the standard of care. And it's protective to the nurse doing the treatments, because if they're following their orders, then they can say, look, I'm just doing things in the way that we said they should be done. So I think we have to stick with the answer of fake, Brad, because I know that what the scenario we get is much like the story today, where people come in and they think it's a retail situation. There's no, the doctor's not going to be present, and we want to have a quick way that someone can come in and get their IV started to cure their hangover, and it doesn't work that way.
Yeah. And I think the other pushbacks that we hear on this is, and I agree with your answer, by the way, is that, well, I mean, it's cash based. I mean, does the practice of medicine still apply if it's cash based, or it's voluntary? They want this treatment because they're hungover, and therefore they should be able to waive that. And what's fascinating about this particular situation is it's still the practice of medicine, is what the state of Alabama said. It's still the practice of medicine, is what we've said over and over again. Yes, we understand that someone's voluntarily coming in here. They're asking for this. They're paying you with cash, but you still have to follow the same rules, no matter what's being paid by, a commercial payer, the federal government, or someone just paying with cash. There are rules that have to be within the standard of care. And what we just established, and what the state of Alabama here establishes, those steps. And that's why it's so important to say fake in this particular answer, because using that questionnaire or standing order cannot get you around those elements of it. And let me, I'm sure the audience members are trying to figure out, well, what happened, I guess, with the IV bar group. And I'll say, Michael kind of hinted at this earlier. They weren't the only ones that got this nice little letter. I believe it was over a dozen different clinics got the cease and desist letter. And there is some confusion there, and we won't dive too deep in it. But the big confusion was, in Alabama, anyone can own a medical facility. So they thought, just because I own it, therefore must be compliant. And again, because it was cash-based, they could do it. And this person had come from a hospital where they had certain standing orders in the ER. So there's a lot of if, what if this happened, what if this happened? And that's the pushback. The concept is ultimately at the very end is you have to remember that no matter where you fall in the spectrum, up and down the food chain of your scope of practice, you can't be delegated something outside of your scope of practice. And that's what was happening in this particular case. And that's why the state of Alabama came in so hard against this particular group. By the way, I'll give you an update. They're actually reopened and they're doing fine, but they obviously had to do telemedicine good faith exams, which I won't go through too much of that today, but that's not the point of the story. But for you, Michael, what are some thoughts that you have before we go?
Well, I mean, I'll say this, that, if you want to have a whale that is going to be your spy and you put a harness on it that has your country's emblem on it and hang a GoPro on it, if you find that whale, it's going to be suspicious, right? I mean, you're going to think, what's going on here? It's either a practical joke or a spy.
Yes.
Well, if you open a business that is treating patients, you're sticking a needle into the arm, you can justify it in your own mind of, I saw an advertisement in the hotel lobby in Vegas and was able to just walk in and get a treatment. And you can justify it as cash-based, as you said, or elective medicine, as you said, but at the end of the day, you can't get around the fact that this is the practice of medicine and the risk is real. And, the moment we always talk about, how are you going to get in trouble? Someone's going to turn you in, a competitor or an employee or a patient. And then, you have to answer to the medical board. And we believe that every state, like Alabama, would interpret IV therapy in the same way.
Yeah. Well, that's awesome. Well, thanks for clearing that up for everyone, Michael. And audience members, that's all the time we have today. But next Wednesday, we continue our quest to determine these legal myths, whether or not they're fake or real. We'll have series regular Jay Riero joining us in the studio to help answer fake or real. The FTC has banned all non-compete agreements.
ByrdAdatto is providing this podcast as a public service. This podcast is for educational purposes only. This podcast does not constitute legal advice, nor does it establish an attorney-client relationship. Reference to any specific product or entity does not constitute an endorsement or recommendation by ByrdAdatto. The views expressed by guests are their own, and their appearance on the program does not imply an endorsement of them or any entity they represent. Please consult with an attorney on your legal issues.